day. This is George McCaslin. I am the online moderator for the Dad's House Educational Group. Today we will be reviewing the article on new child support claims in the Dad's House Manual.
I've been served with child support papers. What do I do now? I didn't know an ex-girlfriend had been pregnant until I was served with papers for child support. After we graduated from college, our careers took us to different cities. And after a couple of months of talking on the phone and emailing, she stopped responding. I just assumed she had found someone new. But now I think she was pregnant and didn't want me knowing. So what happens now?
New child support claims. A man or a woman can be ordered to pay child support. However, since married women are generally the first to file for custody in divorce, and unmarried women have a presumption of sole custody in all states, it is far more common for the man to be the one ordered to pay. There are no justifiable defenses to not being ordered to pay child support, not even in cases of male victims of child sexual abuse, if it results in a conception. Indigent fathers can receive a child support order, even if the amount is set to zero, until their financial circumstance changes. Learning what one needs to be prepared for is important. To begin this process, go to the first link below to gain a better understanding of exactly what child support is, how it came into being, and the different types that can be ordered. In addition, you will likely need an attorney to represent you in this process. The cost of legal help need not be excessive. If you're willing to take the time to prepare, then interview several attorneys before deciding on which one to hire. The second link addresses paternity issues and rights if you're an unmarried man served with papers to establish both paternity and child support. This needs to be reviewed as there are many false presumptions about the rights of men who have fathered a child with a woman to whom they are not married. At the third link is an article on preparing a chronological statement. This is important to limit the amount of time you spend explaining to your attorney on the circumstances of the case. By having this prepared in advance, it would save you at least an hour, if not more, in legal fees resulting from answering questions. Finally, the fourth link will teach you exactly how to conduct the interviews of potential attorneys with a list of possible questions to ask. Financially, the father needs the resources to deal with these three legal issues: custody, access rights, and child support, which are mostly conducted in separate courtroom forums. In dealing in the legal issues of child support, the father will be addressing these costs: his attorney, any needed paternity test, potential retroactive child support, and all court costs. Depending on the circumstances of the support case, such as retroactive child support, the man can find himself drained of any and or all assets, including savings and retirement funds. His income is then attached for 18 to 55% of the gross before taxes until the child has aged out and all remaining arrears from any retroactive order are paid. Don't ignore the summons. One of the dumbest things you can do is to ignore a summons on a child support case. You also should not ignore a summons because it was delivered to the wrong person or the wrong address. By ignoring the summons, you may have a default judgment entered against you, which would require you to pay thousands of dollars in child support. Immediately upon learning that a court action is being pursued against you, it is a good idea for you to contact an attorney to assist you. If you cannot afford an attorney, try to find a paralegal to assist you in filing the necessary forms in response to the documents you have received. Note, if the service is from another state, then you may want to determine if they have long-arm jurisdiction over you. Depending on the circumstances, your state could assume jurisdiction over child support. If not, at the very least, you should personally show up in court as required by the summons and make your appearance in the case. When you personally appear in court, always ask for blood tests to determine the paternity of the child involved in the case, even if you are or were married to the mother. Over 30% of paternity tests come back negative, and women who are married account for 50% of extramarital affairs. This does not mean you want to get out of supporting your children and being a father to them, but aside from peace of mind, you will be fully informed to address future problems. One such issue will be the filing of a custody challenge and being informed that you have no standing in the court to do so as a result of not being the father of one or more of the children. Financial documents. The following is a list of documents that may be relevant to a child support case. You need to be prepared to give these documents to your attorney and the other side, so start making copies now, as it will save you lots of time and money later. Remember that in states where the incomes of both parents are considered in the final calculation, you will want copies of these records from the other side. However, requests must be tailored to the needs of the individual case to avoid frivolous or unduly burdensome discovery requests. Agreements between the parties. Federal and state individual tax returns and worksheets. Gift and sales tax returns. IRS Form 942, which pertains to household help. Business tax returns, federal and state for closely held businesses. Business records and employment agreements, including ownership, assets, liabilities, income, and expenses. Any patents and copyrights. Information on pensions, IRAs, account statements, copies of plans. Information on investments, including account statements, stocks, bonds, limited partnership agreements, reports on investments, net worth statements, personal and business, bank statements, and canceled checks. Trust, medical and dental records, records pertaining to cash expenditures, receipts and invoices by type or above a certain dollar amount, record of charitable contributions, receipts, checks, correspondence, and reports, family budgets before and after the decision to separate in cases of divorce or cohabiting, record of education expenses for parties involved in the case or children, including tuition, room, board, books, contracts, and loans, record of household expenses, utilities, maintenance, improvements, repairs, household help, any other related costs. Court records, cases in which client, spouse, or closely held business is or has been a party. Expense inventory. Here is a list of things that you might be paying for now or in the future. Use this inventory to make an itemized list of your expenses and give it to your attorney. Some of these expenses may be addressable under a rebuttable presumption argument. Start by creating an estimated monthly living expense found at this link. Home mortgage payments. Specify whether the amount includes taxes and insurance, second mortgage and or home equity loan, real property insurance, real property taxes, homeowners association fees, condominium fees, routine home maintenance costs, lawn care including spring and fall cleanup and tree trimming, snow removal, window cleaning, periodic major home maintenance costs such as painting, roof and sidewalk repairs, water softener costs, rent, furniture rental, renter's insurance, maintenance to rented property, food, household supplies, not restaurant meals, utilities, gas, oil, electricity, and water, telephone, home phone, and or cell phone, dry cleaning, cleaning service, how often, clothing, uninsured medical, dental, prescription cost, insured life and disability, child care expenses, daycare costs, babysitter costs, visitation expenses, long-distance telephone calls, transportation costs, entertainment costs, meal costs, support payments required by prior decree, school expenses for yourself and or your children, tuition, books, supplies, transportation, parking, lab fees, activity fees, meal costs, field trips, uniforms, entertainment, movies and video, cable television access, concerts and plays, dining out, in-home entertaining, tickets to sporting events, participation in sports, children's summer activities, camps, etc., children's lessons, dance, music, sports, etc., religious school, children's allowances, children's tutoring, automobile, gas maintenance and repairs, insurance, auto club dues, tolls and parking fees, registration fees, depreciation, installment lease payments, other transportation costs such as a train pass for getting to and from work, etc., gifts for birthdays, holidays, etc., donations, personal donations, donations related to employment or professional standing, installment payments due, name of each creditor, balance owed, payment amount, due date, incidentals, grooming, newspaper, magazines, books, hobbies, pet care, vacations, reserved for replacement of appliances, furnitures, and automobile, membership dues, professional, social, civic, retirement fund, IRA contribution, or other, professional services, accounting, tax preparation, and legal, and of course other expenses that you may think relevant. Demonstrative evidence. Here are some items you might want to prepare for your hearing. Remember, court is an audio-visual experience. People remember best what they can see as well as hear. This includes judges who otherwise might fall asleep during your portion of the case. Budgets. Label the budget clearly. You might use more than one, i.e. actual cost of living and projected cost of living. Use of bar graphs or charts to show differences in income and assets or changes in income and assets over time. Providing advanced copies to the opposing side may help limit objections. Use a chart showing calculations of the difference between gross and net monthly income. You might use a computer program such as FinPlan that is designed to make such calculations. Income inventory. Determine the frequency of receipt for each of the following items so that information can be included in any financial statement. In addition, you may want to note specific amounts on weekly, monthly, quarterly, and annual basis. Salary, bonuses, commissions, overtime, dividends, taxable and non-taxable, interest, taxable and non-taxable, royalties, pension retirement payments, Social Security payments, disability income, unemployment compensation, public assistance, alimony maintenance, hidden income. Most courts base child support on the incomes of both parents. Here are some things you might consider in determining your income and the other side's income. Consider reimbursed business expenses, car expenses, dining out, business trips that include pleasure or vacation component, club dues, education costs, insurance benefits, or other. To find information about a closely held business, contact or have your attorney contact disgruntled current or former employee. Check for excessive deductions, federal and state income taxes, and Social Security and Medicare. Use previous year's limits. Check for unusual expenditures, such as a year's worth of supplies or the purchase of equipment far in advance of need. Check for excessive prepayment of debts, such as estimated tax payments, rent, insurance premiums, and charge accounts. If copies of the other party's tax returns are not readily available, or if you suspect they are not copies of the actual forms that were filed, you can obtain copies directly from the IRS by using Form 4506. Request statement from the Social Security Administration showing other parties' earnings and estimated benefits. Further considerations. Below are links to articles that also relate to the determination of child support. They address the misconception that child support guidelines are mandatory and who should be allowed to take the child tax credit. Be sure to study these articles to be fully informed on your child support rights. Paying the support. Child support payments should be paid through the court, either by sending the payments in personally or having the payments sent by your employer through wage assignment or a garnishment. Some states require that child support payments made through the court be paid by the non-custodial parent's employer to help reduce the number of cases where child support goes unpaid. Employers can charge a fee for handling the child support payments, and the court can charge a fee for processing child support payments. The only way to avoid these additional fees is to agree that the payments will be made directly to the custodial parent and then to make the payments on time. Most attorneys feel that all child support payments should be made through the court system so that there is a public record of the payment. If you decide to pay directly to the custodial parent, make sure you pay by check or money order. The check needs to be clearly marked in the memo section as being made out for child support. In addition to the check or money order, the custodial parent should give you a receipt for the payment. You need to keep these canceled checks and receipts forever or until you die, whichever comes first. That concludes a review of this article from the Dad's House Manual. When using the manual, please consider clicking on the Facebook and Twitter links at the top to share this material with those in your social network. There are over 40 million divorced and single fathers in America, most of whom are searching around for help in the issues found in this manual. Also, fathers are a frequent target of the media and politicians, inciting what they think is wrong with America. They blame us for fatherless children, even though 40% of divorced single mothers deny fathers access to their children. They They call us deadbeat dads, even though only 3% of those ordered to pay child support flatly refuse to do so. They claim that millions of single mothers are not getting child support, without mentioning that 75% of single mothers never applied for any, either due to them cohabiting with the father or not knowing who the father is. If we are to curb the negative picture presented about fathers, then fathers need to be expressing their opinions on it. You can be doing that by writing letters to your politicians and to the editorial page of local and national newspapers. These links will teach you how to do just that. Consider doing it at least once a month. We cannot make our voices heard if we are not willing to speak up. Consider checking out the Zazu stores or Dad's House and Second Wife Club for items to give as gifts or to express your opinion on father's rights. First, we have the main Dad's House store with items of appreciation for fathers. From there, we have the Second Wife Club, also for items of appreciation that you would want to give to a stepmother. Then we have the Father's Rights page, which are items for expressing one's opinion on the father's rights issues. And finally, the Other Face of Abuse store, addressing the issues of male victims of domestic violence. For yourself, take the time to study all the material found here, for only through knowledge do we gain power over our lives. Naturally, this material is available for anyone to use, regardless of what group you are a member of, if any group. But if you have not already done so, consider joining Dad's House to discuss these issues with other fathers and learn from each other's experiences. Naturally, second wives and anyone who knows a father in trouble is also welcome. There is no cost to join and use our materials. Also check out the Second Wife Club for stepmothers.